Well, good afternoon, everybody. My name is Matt Godson. I'm co-CEO with Momentum Event Group, and it's my great pleasure to welcome you all here this afternoon for today's webinar. This webinar is entitled Anticipating the Outcome of Fifth Third on Fiduciary Breach Claims, and it will be my great pleasure in one moment to hand over to our presenters today. Our presenters are Brian Ortelere, who is a partner with Morgan, Lewis & Bockius. He's joined by Jeremy Blumenfeld, also with Morgan, Lewis & Bockius, and he's also joined by Gregory Porter, who's a partner with Bailey and Glasser. Before we get going and I hand over, just a little bit of housekeeping. This session will be recorded, and also the slides will be made available for review after the event, and I will send out everybody to everybody that's on this call. I will send out the details of how to access the recording and also the slides. The panelists will be accepting Q&A after the event, so please do feel free to use the question box or the chat box, which you will find to the bottom of the GoToWebinar panel on the right-hand side. With that being said, it's my great pleasure to hand over to Brian for the remainder of this presentation. Brian?
Well, good afternoon, everyone, or maybe good morning for some of you, and welcome to Momentum's ERISA litigation webinar. We're going to focus today on the Supreme Court's upcoming decision in the Fifth Third litigation. All are hopeful that the court will finally resolve the question that maybe has bedeviled or intrigued many of us who practice in the area, and that's the application of the Third Circuit's presumption of prudence to 401k or ESOP investments in employer stock. Yes, I am Brian Ortelere. I'm co-chair of the ERISA litigation practice at Morgan Lewis, and I'm absolutely delighted to be joined by two stellar practitioners in this space for this afternoon's webinar. I would say that both are seasoned, if not war-hardened veterans of the ERISA class action wars. And first up, my partner, Jeremy Blumenfeld, who for so many years sort of juggled the hand grenades with me as we looked across the no man's land at the enemy. And Jeremy has enormous insights into the issues raised and discussed in this afternoon's webinar. And I suppose to bring some balance to the force, we've enlisted Greg Porter, again a partner at Bailey and Glasser in D.C. And Greg has done long service in these battles, maybe on the wrong side, but he's got the oozing pussy sores to prove it. So why don't we just sort of jump right in. And a brief recap, I submit, of what we're sort of dealing with here, maybe where we're coming from, and ideally thoughts on where we might eventually land once we hear from the Supreme Court. And of course, we're talking about eligible individual account plans offering of employer stock as an investment option. And I probably should note at the outset, or maybe parenthetically, employer stock, at least according to the data that I've reviewed, continues to be a very popular offering to participants, the litigation risks notwithstanding. And the data sets reveal that really plan sponsors have not been all that aggressively eliminating these options since the collapse of Enron. Now, as we know, economists or labor economists have long touted employee ownership as a means to democratization in the workplace, or maybe put a little differently, employee ownership might effectively align the interests of those workers with their managers and shareholders. Now, the question whether these goals, have ever been accomplished or facilitated, I guess, by the offering of company stock is certainly beyond the scope of this webinar, but those interested, I submit, should take a look at Judge Posner's opinion in Summers versus State Street Bank, where he raises challenges to the model. But I say this in large part because I think that these questions about the utility of employee ownership may ultimately inform the Supreme Court's ruling in Fifth Third, but I would point out further that there's really there's been no record amassed here in the Fifth Third litigation speaking to some of these perhaps overarching policy considerations. Now, everybody, no doubt, on this call sort of watched spike in these lawsuits post-Enron and WorldCom. All of us, I think, rode this wave up and yes, maybe down in the face of the Circuit Court's endorsement of the Moench presumption, which we'll tease out the strands of momentarily. But the application of the Moench presumption, or its endorsement by a good number of the Circuit Courts, certainly yielded a drop-off in these types of filings. Now, of course, there's basically two types of claims that are pressed in these lawsuits. You've got the prudence claims and the fiduciary misrepresentation or omission claims. By the way, and I'm dating myself, I think, a little bit, the long view reveals, and those of us that were involved in the first wave of these litigations, really you only saw the prudence claims and the misrepresentation and omissions claims once plaintiffs' counsel were confronted sort of with the onerous pleading burden that arises with the application of the presumption of prudence, and at least it was my belief that these claims, the misrepresentation omissions claims with their sort of liberal reliance on 10b-5 sort of principles and theories of efficient markets, those claims I think were tacked on to try to avoid the onerous presumption of prudence. And by the way, and we'll talk about this in a couple of minutes, and I'm about to lateral all of this to my colleague Jeremy, but some of these issues about particularly related to the viability of the misrepresentation omission claims still bedevil the circuit courts, as the Ninth Circuit's Harris versus Amgen opinion talks about. We'll get to that in a moment.
So I guess one question at the outset, where did this presumption of prudence come from? And obviously one source of potential authority and one source of potential authority that the Supreme Court presumably will point to or discuss has to do with the statute itself. Where in ERISA is there a presumption of prudence and how should it apply? That's a question, no doubt, that some of the lawyers arguing the Fifth Third case to the Supreme Court will raise. Greg may have some views on that as well, but I think it is fair to say that at least explicitly there is no presumption of prudence built into the statute itself, into ERISA. What there are a few exemptions that are particular to employer stock and a few more general provisions. And the first one that's hopefully you can see on your screen there talks about the diversification requirement and the prudence requirement, to the extent it requires diversification, are not violated by holding qualifying employer securities. And one could really delve down into the details of what is diversification and where is the prudence requirement overlapped with and different from the diversification requirement. I've seen the argument made, and I think I've made the argument in certain cases, that prudence has to do with whether holding even one share of a particular security would be appropriate or is a good idea or a bad idea. And anything else, really, whether you should hold 2 shares of it or 2,000 or 2 million, is really a question about diversification, particularly when you consider the long-term nature of these investments. And one could use, for example, the statute itself, these provisions, and the definition of diversification and prudence as a basis for justifying a presumption of prudence applying. There also are specific statutory exemptions that excuse the 10% limit on employer securities from certain eligible individual account plans and ESOPs. And the reason for that has to do with Congress's desire to encourage employee ownership of employer securities in and of itself, putting aside the performance of the investment. And there's also sort of tell of that in the legislative history regarding the employer stock investments, and also baked into the statute, although not identified in the materials here. It's more later on. Whenever reviewing the prudence of investments, it's supposed to be with an eye towards how a similar investment would be used in the conduct of an enterprise of a like character and with like aims. And maybe that puts the rabbit in the hat, but if you're looking at the investment in terms of an employer stock investment, is it fulfilling the goals of an employer stock investment, which is another statutory basis that no doubt the Supreme Court will have to look to, and that the courts of appeals that have decided and developed this presumption have looked to.
Of course, we start today's journey by revisiting the Third Circuit's opinion in Moench in 1995. And I guess, depending upon your perspective, the Moench opinion is either I guess, the holy grail of jurisprudence in the area, or maybe if you're coming at this from the other side, the root of all evil, sort of a multi-headed hydra spitting and spewing some noxious influence across the emerging case law, and indeed it's had some spillover elsewhere, and we'll talk about that in a little while. I submit that the opinion, I think, reflects something of an excess of judicial hand-wringing, but it should be revisited. If you're interested in this area, and again, concerned about where the Supreme Court might land on this, Moench has to be considered with some care, not the least of which reason, I think, is that it does rely on Supreme Court authority to come to the conclusion that these sorts of investments can be presumptively prudent. And specifically, and I think interestingly, there's a rather fulsome discussion of Firestone versus Bruch, along with, and one might expect this given the Third Circuit's ruling, sort of I think a full-throated endorsement of the supposed benefits of employee ownership. Again, it's sort of catnip to defense lawyers, but maybe nails on a chalkboard to other people. And again, I'll just pause for but a moment more before lateraling the ball back to Jeremy for some observations regarding the backbone of the opinion. But I think that at least what I find particularly interesting is that reliance on Firestone versus Bruch. And of course, probably everybody on the call well appreciates Firestone's application to 502A1B benefits claims, and certainly where the plan document has the requisite reservation of rights language in it. Ideally from a defendant's perspective, a reviewing court will defer to the judgment of the fiduciary committee denying the benefits. But there is some language in Firestone suggesting it doesn't necessarily apply only to benefits claims, although the Supreme Court didn't resolve that question. But that said, I think, and Moench and these Supreme Court proceedings in Fifth Third beg the question, I suppose, or we may well soon learn whether or not deferential review is appropriate in the context of fiduciary breach claims brought under 404A, which in turn might yield or incent people to sort of ratchet up plan language around some of these questions in the hope of judicial deference. And of course, as I think I alluded to a moment ago, if the Supreme Court were to go down that path, you would have questions or perhaps much broader application of a ruling here. And by the way, this issue, Tibble versus Edison, the Ninth Circuit, has sort of been flirting with this question. So it's really not an inferential leap to conclude that the Supreme Court may well get there in its ruling.
So one of the really interesting things about the Moench opinion is it is an opinion that people actually could look to when they are operating and administering a benefit plan to really get a sense of what the fiduciaries are or are not supposed to do, depending on the plan language. And what the Third Circuit in Moench concluded, and parenthetically, I should note that I think the parties in the Moench case and the Third Circuit in issuing the opinion probably did not envision that that opinion would be such a pillar in terms of the case law nationally for addressing all of these stock drop claims and ultimately making it to the Supreme Court. But what the Third Circuit said was the rule is relatively straightforward. At common law for a trust, if the trust was required to make a particular investment, then the fiduciaries don't have any discretion about making that investment unless it would be illegal or impossible to comply. And therefore, applying that to ERISA, if an ERISA plan required that a particular investment be offered, then the investment is required to be offered, and the fiduciaries really have no discretion about eliminating it or evaluating the prudence of that investment as an investment option. And similarly, if the investment is encouraged in the language of the Third Circuit, that is, there is language suggesting that is more than just permissive, that it is part of the goal of the plan, for example, to offer the investment, but not actually mandatory, then this presumption of prudence should apply, because that is what would have typically applied at common law when dealing with the trust outside that arena. And thirdly, if you dealt with a trust that was wholly discretionary, that had a lot of different investment options available to it, or that didn't identify any particular investments but just left that to the fiduciaries to decide, then that would not be subject to any deferential review and would be reviewed just like any other investment. And that was a standard that the Third Circuit articulated, and that seemed like a reasonable guidepost to fiduciaries, at least in engaging in first instance.
Now, certainly the Moench presumption has gained wide acceptance among circuit courts, which again, that's either the myth or the beauty of the ruling, depending on your perspective. Now, I would say that the standard does vary among the circuits, and somewhat nuanced differences are reflected in case law, but sort of quite simply in putting the Sixth Circuit's rulings, and there are probably two of them which we will cover with some care today. The circuit courts that have adopted Moench have generally held that claims challenging an EAPS, which includes, of course, ESOPs, continuing investment of employer stock, I suppose in the face of downward pressure on price, are presumptively prudent. In other words, and again, putting aside to the Sixth Circuit's ruling, the other circuits that have addressed the issue have basically held that a complaint will be dismissed on a 12b6 motion to dismiss unless the plaintiff affirmatively pleads that the plan sponsor's circumstances were dire and related to that, its viability as a going concern somehow in question. And when I spoke earlier of the difficulties involved in rebutting the presumption, there you can see plainly the problem from plaintiff's perspective. It's an enormously high burden, and interestingly, at times, it's taken down the fiduciary misrepresentation or omission claims with it. The Fifth Circuit, for example, in Kirschbaum versus Reliant, basically said that whether or not stock is indeed artificially inflated really doesn't much matter. Sort of the same policy considerations apply, and unless and until a plaintiff can rebut the presumption of prudence, the fiduciary omissions or misrepresentation claims should be dismissed as well, although we'll see again in a moment the Ninth Circuit's gone in a different direction on that.
So the next sort of question when litigating these cases, which of course bears on the risks associated with the investments more generally, at least as it bears on the fiduciary's potential risks, is the timing. When does this presumption of prudence apply? When might it apply? And a number of the courts of appeals that are identified in the materials, the 2nd, 3rd, 5th, 7th, and 11th, have all indicated that it can be appropriate to apply the presumption of prudence when considering a Rule 12 challenge, that is, a motion to dismiss before any discovery. And this is a really important component to application of the presumption and to giving the presumption the effects that it's supposed to have, at least if the presumption is supposed to apply at all. One can refer to the Private Securities Litigation Reform Act and the discovery stay and the heightened burdens of proof and pleadings that apply under that standard. And what can happen and has happened in some of the ERISA stock drop cases is that the discovery that is stayed in the securities case is allowed to proceed in the course of the ERISA dispute, which then can sort of feed onto itself and help support or buttress the securities case with evidence or materials that are obtained in the ERISA case. And although the ERISA cases typically are smaller, at least relative to the securities case, oftentimes the discovery burdens can be just as broad because the allegations reach to the upper echelon of the organizations, oftentimes CEOs, CFOs, board committees, about what they knew when they were making statements to the market, what they knew about future profitability, future forecasts regarding sales, and things of that nature. And if that discovery is permitted to proceed, the costs and burdens of it are enough to cause people to rethink at times these investments in employer securities. And the existence of this presumption have avoided a lot of costs, a lot of expense, and a lot of wasted time for defendants. First of all, the lawyers having to gather materials, and second of all, witnesses having to be deposed, prepared for depositions, etc.
This is Greg Porter speaking. Just before we turn to page 8 of the program, I want to note that, the notion that you have to plead dire circumstances to overcome the presumption is really only lip service, I think, to the possibility of a claim, because if Citigroup, for example, wasn't in dire circumstances at the time of which the plaintiffs alleged it was an imprudent investment, it's hard to imagine what would be. I mean, Citigroup was on the ropes, and the companion cases out of the Second Circuit, Bear Stearns and Lehman Brothers, with both those companies collapsed completely, but yet those claims were dismissed. If those aren't dire circumstances, then it's hard to see how a plaintiff could ever overcome that pleading requirement. So really the beginnings of the Fifth Third decision are found in the Sixth Circuit's decision, which preceded it, the State Street Bank case. And in that case, the court said that the presumption of prudence adopted in Cupper was not an additional pleading requirement and does not apply at the motion to dismiss stage. Although that's inconsistent with what many of the other circuits have held in the employer stock context, it is pretty much consistent with the general rule under the rules of civil procedure as interpreted by the federal courts that the courts aren't supposed to impose heightened pleading standards without statutory guidance. So, for example, you might have a specific statute that imposes specific pleading requirements beyond those required by Rule 8 or Rule 9, but absent explicit language in a statute, the courts are generally not supposed to impose heightened pleading standards. So it seems to me, at least from my perspective, that at least this aspect of the Sixth Circuit opinion in file and later followed by the Fifth Court is dead on. So that's the background, and so really, I mean, Fifth Third is really the natural consequence of the file of the State Street case, on which the Supreme Court denied cert. Not altogether clear why the Supreme Court decided to accept cert in Fifth Third when it had denied cert in the prior case, but nevertheless it did so. In the Fifth Cert case, what we have here is a so-called hardwired option. And the plan commanded the plan document commanded an employer stock fund. And then you also have other relevant issues such as SEC filings being incorporated by evidence. And then you have the core allegations of imprudence about how the bank went from being a conservative institution to a subprime lender. Its stock was artificially inflated and later dropped by 74%. And ultimately, the court concluded that the presumption should not be applied at the pleading standard, but only should be applied after a full evidentiary record. And again, echoing, if you see, the quote we have here in bold, we are not free to limit the standards set by the statute. That's sort of echoing the point I made earlier that the courts aren't really at liberty to impose pleading requirements that are not found in the statute. So that brings us to the misrepresentation holding. Before I hand this back to everyone, I think Jeremy to talk about the misrepresentation aspects of it. I think Brian mentioned a Posner case earlier, and I have another one for you. It's LaSalle National Bank, and that's a Posner opinion in which Posner sort of speculated about how one might allege a breach of prudence claim in the employer stock context that did not involve diversification issues.
Thanks, Greg. Turning to the misrepresentation/omission holding in Dudenhoeffer, something that many of you may see and experience in your own workplaces. Really, the question at issue that was presented in that case and a number of others is what happens when you have SEC filings and Form S-8s that are incorporated into what otherwise would be fiduciary communications like a summary plan description. And I gather the reason that many employers do this is because they're trying to avoid having to send lots and lots of paper to plan participants every quarter or every year about the individual investments, and so they incorporate that material into a summary plan description. And the question really boils down to, if you do that, is any communication that you make to the Securities and Exchange Commission in a filing automatically become a fiduciary communication subject to ERISA's disclosure obligations? And the Sixth Circuit said in Dudenhoeffer is that ERISA requires the issuance of an SPD but does not require that you incorporate SEC filings into an SPD. And so if you do incorporate those SEC filings into your summary plan description, that is thereby making that fiduciary conduct. And the courts of appeals really have gone in lots of different directions on that, largely depending on how they come out on the underlying presumption of prudence theory.
By the way, just to jump in here for a moment, Jeremy, interestingly, and you can see this in the government's amicus brief filed in the Supreme Court after the cert petition was filed, that the United States government, the federal government, pointed out that Dudenhoeffer on this particular narrow question is really the only ruling, the only circuit ruling on this issue as stated, and from that premise argued that there was no circuit split, and apparently the Supreme Court agreed with that, and that's why they denied the request for review on that issue. Sorry.
Yep, and the last piece of what Dudenhoeffer talks about that's worth mentioning now is that efficient market theory, loss causation, presumption of reliance type issues were really not anything the Sixth Circuit was interested in tackling on Rule 12b-6, and therefore it didn't discuss sort of how securities law and the fraud on the market theory might intersect with these kinds of things, and likewise how a defendant's arguments that if you force fiduciaries to sell based on material non-public information, either they will be violating federal securities laws, or if the information is revealed, they will cause the very drop in the stock price that the plaintiffs are complaining about in the first instance. So as Ryan mentioned, the United States in Fifth Third in their amicus brief said there's no split. The one thing that the United States did say is that the Supreme Court should take up the presumption of prudence issue itself, and said in its petition that the Supreme Court should take the case and affirm its ruling because it did not believe that the presumption of prudence should apply, at least at 12b-6 or at any stage of the proceedings. It's worth noting, subsequent to that briefing, the Ninth Circuit came out with an opinion in Amgen, which I think we'll talk about in a few moments, that touches on that disclosure piece and maybe further solidifies the circuit split issue that was mentioned a few moments ago.
I'm not sure how much predictive value this has, but at least some prognosticators that I've discussed these issues with put some value, interestingly, in the way the question was framed by the Supreme Court in the order granting cert in the wake of the bank's petition for review. The court accepted verbatim the bank's framing of the issue. The first question presented in the cert petition. As I said a moment ago, the court refused to review the issue presented on the incorporation by reference question. Now, interestingly, and again, some find meaning in this, the Solicitor General's brief, on the other hand, asked the court to sort of simply determine whether a rebuttable presumption exists, I would say completely unencumbered by the florid language that you can see there in the order related to the sort of the weight of authority supporting application of the presumption. Again, those closer to the, or members of the Supreme Court bar or regular litigants in front of the Supreme Court seem to think that the Supreme Court might indeed have telegraphed its ruling by framing the question as they did.
I just have to say, though, that it's hard to imagine that the Supreme Court could determine the question of when a presumption should be applied without first determining whether there's a presumption at all. I mean, it seems to be putting the cart before the horse.
I certainly would think that you hope that's true, Greg.
Because it leaves the question open for another day. I mean, it doesn't resolve the threshold question.
Well, I guess one would presume that if they're going to say that the presumption needs to apply at some point, then yes, they're going to have to say that the presumption applies and here's when. And likewise, they're going to say it never applies. That presumably answers the question in the same way.
Right, right.
I would say, notwithstanding how the question is presented, one thing that I think all of us speaking today are pretty confident of is we're not willing to bet anything of consequence on the likely outcome from the Supreme Court or how the votes are going to get cast. One could certainly try and make guesses about individual justices and how they're likely to rule and make the arguments for or against in any given circumstance, but obviously we'll have to await the ruling in order to really know sort of where things stand. But some things that the Supreme Court likely will look to in the course of deciding the issue, presumably one of them will in fact be the statutory language. The Supreme Court frequently refers to the fact that ERISA is a comprehensive and reticulated statute with a carefully crafted enforcement mechanism, and it would not be surprising to see that kind of language in the court's opinion. Interestingly enough, I think, Greg, we would all agree that's likely to be in the court's opinion regardless of which way the Supreme Court comes out, because those are sort of general principles that can justify perhaps either outcome. I did want to bring to this group's attention something that I thought was interesting from Justice Scalia. He's quoted as having said, "What is a moderate interpretation of the text of a statute? Halfway between what it really means and what you'd like it to mean." And I think that is true probably here as well, regardless of which side one is advocating for. One could also imagine that the plan document also will reveal its importance again in this opinion. We've talked before during this webinar about sort of hardwiring language and putting into the plan document a provision saying that a particular investment either is required or is encouraged, and the Supreme Court's focus on the plan documents may lead it to conclude that that kind of language in this circumstance should be as enforceable as the same kind of language regarding, for example, statutes of limitations, or what kind of equitable liens a plan fiduciary might have in plan assets that are given to somebody who subsequently has a personal injury accident, or all of those other circumstances where the plan document itself governs, in the Supreme Court's view, the outcome of the case. And then there are these more general principles from trust law, very similar to what the Third Circuit pointed to in the original Moench opinion that we talked about earlier. And the Supreme Court has, when it felt it necessary or appropriate, looked to trust law principles, and when the results from those trust law principles didn't support the outcome, there is always the yielding of common law trust principles to the statutory text and purposes of ERISA to the extent those things diverge. Another thing that the Supreme Court has done in other cases.
If I could just comment on borrowing from trust law for a second. While it is true that most of the courts that have found a presumption of prudence have focused on the plan document and the deference to a fiduciary's decision in following the plan document, they've really only focused on the prudence claims and almost always seem to gloss over the breach of loyalty claims. There is absolutely no precedent in the trust law for deference to a fiduciary on a breach of loyalty claim. Zero. So I think the courts have been less than honest in grappling with that claim.
Well, it's a fascinating area, again, in Moench, whether the Third Circuit went off the rails or not, there's sort of any number of ways to look at the problem presented. And, for example, 404A1D, which sets forth the primacy of the plan document, which, again, might suggest some opening where trust law principles might be brought to bear. And, again, in Moench, you'll see sort of repeated citation to the restatement of trust and the varying standard of reviews that might arise depending upon, the extent, again, to whether or not the plan mandates the investment, whether it encourages the investment, or is silent on the issue. But you've also, nevertheless, right in that same section, 404A1D, you've got that prohibition, if a plan document is otherwise unlawful under ERISA, perhaps a court should not be so eager to rely on it.
Well, and the other aspect of what the Supreme Court may touch on in this context has to do with the efficient market hypothesis and prohibitions against insider trading. One of the things that some of the courts have wrestled with is if the fiduciaries are supposed to do something for the plan, as sometimes is alleged in these employer stock cases, can they do so based on the material non-public information that they have? Is there some duty to avoid engaging in insider trading? One sort of middle of the road compromise position has been to say that the fiduciaries can't allow new investments, for example, when shares are allegedly artificially inflated, but are not required to sell their existing shares. Putting aside that may be more a question about diversification as opposed to prudence, as I suggested earlier, it doesn't really get to the heart of the matter and is using what at least we on the defense side would refer to as really hyper-technical readings to encourage essentially either trading or not trading based on material non-public information, which is not something that we think at least Congress would have ever wanted. Putting aside whether it ever prohibited it, it doesn't seem like there's any basis to say that Congress wanted people to be able to either profit or avoid losses based on material non-public information.
I would say there's really no surprise here, and I think we've touched on this point briefly. The bank and its amici sort of vigorously argue that the reasonableness of the investment, of any investment in employer stock, has to, sort of under 404A, has to be considered next to the goal of these investments. And these parties argue certainly that the goal here is employee ownership. And taken to its logical conclusion, it's really only at bankruptcy is the purpose of employee ownership somehow impaired. And there is the argument made that employee participants will be incented by a declining stock price to sort of work together to right the ship, so to speak, so that these investments certainly have to be considered through a different and entirely different prism than perhaps the other investments in a 401k plan. But
to me, Brian, that's a little bit like arguing you can only attempt to resuscitate the patient after it's been brain dead for 10 minutes.
Well, again, and certainly, Greg, I will appreciate where you're coming from, but if you accept the premise that there are special risks associated with these investments, and those risks in turn sort of create incentives. One might, or likely no member of the plaintiff's bar, but others might reasonably conclude that the standard should be different.
Well, and I would add further, there is and has been in a number of these cases a rise in the price of the stock after the decline that necessitated the lawsuit.
Sure. But I guess, if we were talking about the statutory guideposts, I mean, it's basic statutory construction that where Congress creates an exception, as it did for employer stock with respect to the duty to diversify, and they did not create such an exception with respect to the duty of prudence or loyalty, one must presume that Congress did not intend employer stock to be in any way, shape, or form to be exempted from those other duties, and that's basic statutory construction.
Well, I will concede only this much, Greg, that the litigation presents something of an intellectual smorgasbord when you get to application of rules of construction and the like, and the extent to which, and again, and already touched on in the presentation, whether or not there indeed is any sort of wiggle room in the statute for the presumption, and maybe yes, Justice Scalia, who to my understanding can be sort of hard-nosed on such statutory construction issues, per the quote that Jeremy shared, perhaps Justice Scalia may influence how this comes out, although my suspicion is he may be sympathetic to the concerns of employer plan sponsors.
And I would add one other piece to that, which is the position that you're articulating, Greg. Obviously, we've seen it and heard it before, and I understand your point. At the same time, whether the claim that is being asserted is in reality a diversification claim, even if somebody wants to put a different label on it, is a question that really may resolve and address the concerns you're articulating, especially if you think about sort of what it means to diversify and the risks associated with investments. And what we're talking about oftentimes are investments in companies that are part of, for example, the S&P 500. And hundreds of other investors, hundreds of other fiduciaries, therefore, hold such investments as part of an overall investment portfolio. And the distinction here is the holdings are often a much more significantly large portion of the concentration of the investments in the plan, as opposed to maybe 0.25% or less in a typical non-ESOP or EAP plan where the holding is part of some larger investment portfolio. So that those are all kinds of issues that the Supreme Court may end up wrestling with, and maybe we'll get some answer from different members of the court as to what the duty of prudence is and what the duty of diversification is and where we should all put our retirement monies as a result.
Again, it's something of a beautiful thing, I submit, sort of the way these questions interrelate. And yes, when employer stock is simply one of many offerings on a 401k investment platform, is it the overarching goal of the 401k plan, which is typically to amass retirement income, is that the defining standard as you look to what is the goal or objective of the plan under 404A? And I suppose for a moment, Greg, I will uncomfortably carry your water on this issue, but in a circumstance like that, again, where employer stock is but one of many, many different offerings, one could indeed challenge the assertion that this is how the investment should be scrutinized, or maybe it's just part of a larger portfolio. But then, and again, and this is why Dudenhoeffer so excites the ERISA litigation bar, you get back to would an expression of purpose related to an employer stock fund, how does that fit in to the calculus after rulings like McCutcheon and Amara with their emphasis on the sanctity of the plan. But again, sort of all of these things, there are interrelated at so many levels, and much to await breathlessly here.
Well, I think that's a good segue, because I think in terms of, or a good tell about how the Supreme Court might come out on this, because if the Supreme Court opinion is focused on what the statute says, as opposed to what the plan document says, then I think the plaintiffs have a better chance of winning.
But you would also concede, and we spoke of the possible mischief that might flow from a ruling that looks that emphasizes, the plan language.
Sure. If the Supreme Court focuses on the primacy of the plain language, then I think we'll see plan sponsors hardwiring other investment options and attempting to insulate the fiduciary process from any scrutiny whatsoever.
But in the meantime, the mill still turns while we all await the Supreme Court's ruling. Interestingly, but a few months ago, the Ninth Circuit decided the Amgen opinion. We've touched on this again, and questions abound for practitioners because, surprisingly, after rulings like Wright versus Oregon Metallurgical, computer science, there were a series of Ninth Circuit rulings that I think fiduciaries and plan sponsors found tremendous comfort in. Along comes Amgen, although I think it's not terribly surprising, at least on the threshold prudence issues. The plan there could not even be said to encourage investments in employer stock, and the takeaway, of course, and Jeremy will talk about life in the world we live in today momentarily, but one takeaway obviously from Harris is that hardwiring such a plan, at least unless and until Dudenhoeffer is decided, is a valuable thing. But sort of actually what I tend to believe is the more interesting aspects of Amgen, relate to the misrepresentation and omission claims. The Ninth Circuit might actually be the most strident, or the first court perhaps, to rule that, simply in adopting an argument that the Department of Labor has been making seemingly forever, at least in every amicus brief in litigations that I was involved in, the DOL would come in and say, always and certainly keeping securities in the portfolio that are somehow artificially inflated, as those terms are understood under efficient market theory, is a breach in itself, quite separate and apart from whether or not the presumption of prudence has been rebutted. And the Department of Labor has long taken issue with that aspect of the Fifth Circuit's ruling in Kirschbaum, which again, the Fifth Circuit seemed only too eager perhaps to sweep under the rug the misrepresentation claims, deeming them something of a subset of the prudence claims.
Just as a matter of common sense, it's hard to imagine that it could ever be prudent to purchase an asset that the fiduciary knows has been fraudulently inflated in value. Now, that assumes the fiduciary does know, but, how can that be prudent as a matter of common sense, putting aside anything else?
And I think, Greg, that's where sort of we see some of the courts talking about the long-term nature of these investments. And even if in the short term the shares might be artificially inflated, as is alleged in these cases, over the long term, if they are expected to still perform and do well, and the company is expected to perform and do well, then maybe it's not a problem to purchase shares at a higher price than you might hope to get it for, recognizing that you don't know if or when you would be able to get it at the uninflated price, as is sometimes alleged in these cases. One of the other aspects that I think Brian mentioned a moment ago about the Harris versus Amgen case had to do with the misrepresentation claim, and whether that claim separately or in conjunction with the prudence claim could survive. This was another circumstance in which the summary plan description incorporated some of the SEC filings, and the Ninth Circuit, consistent with what the Sixth Circuit had said, concluded that because you affirmatively took the steps to incorporate your SEC filings into what is an admittedly fiduciary communication, those communications and thereby your SEC filings, et cetera, are deemed fiduciary communications governed by ERISA standards. I think the folks who were probably working on those communications drafting them and preparing them to go out to the market, had no idea at the time that that was happening, that those might be communications subject to ERISA, and query sort of the next step in those kinds of proceedings is whether all of the advice that is sought in connection with those disclosures is all of a sudden subject to the fiduciary exception to the attorney-client privilege, so that any SEC filings all of a sudden become, the drafts of such filings become discoverable in an ERISA case when you're fighting about the scope of the fiduciary exception to the privilege. Interestingly enough, in the Amgen case, one other aspect that doesn't get talked about as much, I think, is that defendants were arguing, look, this wasn't a big drop in our stock price. This was sort of a blip on the radar screen, and the Ninth Circuit kind of turned that around as against Amgen in that case. Not on the prudence claim, but when it came time to the disclosure claim, the court said, look, you've been telling us that this was not a big drop in your stock price, so when it comes to the disclosure piece, how can you tell us that had you disclosed the information earlier or stopped the plan from purchasing new investments because of the disclosures, that the stock price would have gone down very much, because you've already told us that the stock price didn't go down very much when the disclosures actually were made, and the misrepresentations that were alleged in that case came to light and were revealed to the market. One of the other aspects of Amgen that is worth noting and may distinguish it from a lot of other cases is that the plaintiffs or the shareholders were able to assert in a companion 10b-5 case claims that survived a motion to dismiss in that case. And the Ninth Circuit looked to that and said, if you can state a claim under securities law, then how can it be that you can't state a similar claim under ERISA?
I think that no discussion of employer stock or 401k plans generally is complete without at least touching for a moment on ERISA Section 404C. There have been additional recent rulings from the circuit courts. I suppose from a defense fiduciary plan sponsor perspective, none of them particularly good. The courts are now sort of embracing enthusiastically more DOL, the new DOL guidance on the meaning of 404C, which I think you can assume the DOL concluded had to be tightened up in the wake of rulings like Unisys and Langbecker. But I find this this area of the law to be somewhat schizophrenic. I'd always hoped maybe someday the Supreme Court would indeed take this up, although I don't think the question has yet, well, certainly have not taken it up, but I'm not certain it's been squarely presented. Interestingly to me, the Klein case cited there on the slide, you know, you've got the Fifth Circuit doing an about-face on these issues despite Langbecker, which they don't even bother to mention. Their earlier ruling, which relies on the primacy of the statutory language, much like the first Unisys Savings Plan opinion. And I cling to this Unisys ruling that I got so many years ago, because indeed I thought the Third Circuit had it right when it said the language is abundantly clear and there really isn't room for the DOL. The DOL, their narrow construction of the language. Again, Tibble went in the same direction very recently from the Ninth Circuit. To me, it's an area that defies, I think, satisfactory explanation. You know, with courts like the Seventh Circuit flipping all over the place, deciding Motorola and sort of overruling their earlier decision in Deere, which adopts Langbecker, and Unisys. And then baffling to me is the fact that Motorola, on alternative grounds, affirmed the judgment of dismissal there, saying, gee whiz, the participants could have moved their money someplace else and avoided the supposed losses, which something we call here at the firm 404C light, sort of a common law causation 404C defense. But really nothing good to report on 404C of late for defendants, good stuff for plaintiffs.
If I could just sort of close with this comment, the exemption for employer securities also applies to qualifying employer real estate. And I would ask, if the plan was hardwired to require holdings in employer-owned real estate, for example, insurance companies tend to own a lot of real estate, and the employer sold its real estate at an artificially inflated value, and pursuant to a fraudulent appraisal, for example, and the fiduciaries knew that when they acquired it, it would seem to me that that would be imprudent. And I'm wondering how one could square, and I know we can talk about all we want to about, the securities trading on a public market and trying to second guess the value of that market. But, it's very difficult, given the structure and language of the statute, that it treats, for this limited purpose of employer-owned real estate and employer securities, essentially the same, how you could have a rule for securities that would be different from a rule from employer-owned real estate.
I think, Greg, you raise interesting questions, which is no doubt why the Supreme Court is interested in taking up this issue and sort of wrestling with all these points. There are snippets in the language that both sides can point to that support their view, and really it's going to be the Supreme Court that has to cut through it all and decide what the right course of action is here, and ultimately what fiduciaries are supposed to do when faced with a scenario where they know that over the course of the next 6 months or 1 year or 2 years, investments in the company, or at least the company's sales, might not be as robust as they had hoped, or that there might be a dip in earnings, or conversely that something really good might be happening to the company, and how, on top of everything else they are supposed to be managing within the organization, and on top of how they're supposed to be handling the securities markets generally, what special conduct, actions, behavior, considerations they need to make with respect to employer stock that's held within the plan. And one of the things that Brian alluded to early on in the discussion is that, at least so far, it doesn't seem like the litigation risks have changed behavior at the outset in terms of whether employer stock is offered in plans in the first instance. But no doubt one of the concerns that the Supreme Court will be discussing, and that a lot of the amici have raised in the Dudenhoeffer appellate briefs, is that employers will just stop offering employer stock, and will that frustrate Congress's goal of encouraging employee ownership in the first instance? So, with the last slide here, or second to last slide, is best practices in an uncertain and unruly world. Prior to the Sixth Circuit's opinion in Dudenhoeffer, and prior to the Supreme Court taking the case up, I think there was a lot of suggestion on the defense side, at least, that the conduct really that should change, if anything, is what is in your plan document. Should you have language that would satisfy the Moench standard and entitle you to some sort of presumption? Right now, if people were to ask me, I would say it's really, you're better off sitting tight right now. At least that would be my advice. The Supreme Court's going to decide the issue in the next few months. As I've been known to say in a number of other circumstances, the only way to avoid getting sued in an ERISA stock drop case is not to have any employer stock in your plan in the first instance. But that, I would say, sit tight and see what guidance the Supreme Court has to offer right now.
By the way, Matt, are there any questions?
We just have the one question, thanks, and that's about the timeline for the Supreme Court proceedings.
Oh, whoops. The argument is scheduled for April 2nd, and the decision should issue by the end of the term?
Yeah, it should be before the end of June is when the decision is most likely to be issued. So.
And by the way, it is our hope, and I think all of you will be hearing from us immediately after the ruling, to schedule another session where we can pick apart and tease out the varying strands of the opinion, which again may have an enormous impact even outside of the narrow world of employer stock holdings in EAPs. With that, I'd like to thank everybody for their time, and if anybody has an additional question, feel free to email all of us, and I'm happy to call you back and kick this around some more. Again, thank you, everybody.
Yep, thank you very much indeed. That was a really amazing, excellent, informative presentation, and it will be great to have you back after the Supreme Court proceedings for an update. With that being said, I want to thank you, all the presenters today, for the hard work that's gone into their presentation. Just to remind you, we will be recording. We have recorded this, so I will send out a link to everybody that's on the webinar so that you can review this at your leisure. And with that being said, I also want to thank everybody that's taken the time out of their day to be part of this webinar, all of the attendees on the call. And I wish you a very good day. Thank you very much.
Thank you.